Welcome to my lecture review on my book, eDiscovery. I take that back, it's not my book, but it's one of the books that I'm using for my courses. So eDiscovery, the book is an introduction to digital evidence. Chapter 1, again, intro to eDiscovery and digital evidence. Objectives is to define eDiscovery and digital forensics, describe types of digital evidence, explain factors affecting digital evidence, summarize federal rules. Can't really do state because depending on what state you're in, the rules may be different, again, depending on the state. And lastly, describe other laws related to digital evidence and ESI discovery. Alright, so, first of all, ESI. What does that mean? I like how they introduced an acronym before describing it. ESI is the electronically stored information, such as documents, emails, photos, web pages, and databases and other productivity files. Alright, so let's go back to eDiscovery. eDiscovery process is the process of applying traditional legal discovery process to electronic evidence. That electronic evidence does encompass ESI. ESI can be found on pretty much any type of computing device. eDiscovery is a form of data mining. It's a method that companies use to gather data, and data that can be turned into information about customers, vendors, victims, attackers, and so forth. Digital forensics is a scientific methodology of extracting data, or in this case, evidence, from a digital device. Digital device can also include an active network, because a network is a digital network, and yeah. Following this procedure ensures information will stand up to scrutiny in court. That means it's a scientific methodology, it's a structured method that's been proven, so you can present findings in court. The field of digital forensics is divided into two main types. Device forensics, like computer, like mobile devices, things like that, and network forensics. Device forensics normally deals with existing files, deleting files, deleted files that are hidden, encrypted files and other encrypted data, and things of that nature, while network forensics deal with the network intrusion and hackers. Network forensics sometimes is more geared towards incident response, though incident response can encompass both. Key differences between eDiscovery and digital forensics is digital forensics investigators are typically looking for incriminating or exculpatory evidence in a criminal case or an investigation of a corporate policy violation, while digital forensics can be considered to overlap with eDiscovery. They're not mutually exclusive. Network forensics do not consider eDiscovery to be related to their jobs. eDiscovery experts might have to call on device forensics experts to retrieve data. So eDiscovery, you're not going to be as specialized, and some of the more specialty may not consider themselves part of digital forensics. Here's an example. eDiscovery could encompass a large amount of area, where digital forensics may only encompass a small portion of eDiscovery. But there is overlap between eDiscovery and digital forensics, and this varies depending on who you talk to and what year you talk to them. A typical overview of eDiscovery is the type of evidence examined in an operating system. Things like the MAC time, the modification, access, or create times, both dates and times, file access, network logins, those are examples. If we're talking more specific operating systems, we could have a Linux person, and that Linux investigator might be able to retrieve time files that were deleted and were accessed. One of the major challenges in dealing with eDiscovery involves both the legal field and the highly specialized IT field. It takes a unique person that understands both the legal requirements and has the specialized IT training to do e-discovery and digital forensics. So again, types of digital evidence could be data, could be files, which files are data, anything in a digital format that pertains to a complaint. The complaint could be either civil or criminal. Cameras, watches, fax machines, again, anything digital. Emails, same thing, anything digital. So the types of things could also include like phones, SIM cards, almost anything that has a digital connection. Refrigerator, if it's a smart refrigerator, coffee pot, if it's a smart coffee pot, and so forth. And we have to understand two big terms, data and metadata. Data is actual information being retrieved, such as like a document, a photo, PowerPoint, and so forth. Metadata is the information about the data. Metadata, for an example, in a photo can tell the investigator the type of camera, the type of lens, the date, GPS, where the photo was taken, well, that's tied to GPS, and further details. Here's an example. This was taken by a Canon photo shot, date, time, size, GPS coordinates, the type. It may even say the lens type depending on the device. To access the phone's metadata, typically we can explore the details, properties and details of the item. Here you'll notice we have the f-stop. The camera is using a 2.7 aperture. It lists the exposure time, ISO speed, all that detail. There are other ways to look at the details. You can have a forensics program like FTK Access Data, or Access Data's FTK. I said that backwards. Or like Encase. Metadata also is available for documents, PDFs, pretty much any digital item. There's going to be metadata. Recent court cases have cited or fined companies for deleting that metadata because that metadata is part of the data. However, including metadata showing who worked on a particular file might violate other standards, such as like privacy regulations, copyright infringements, and other laws. Hence why a forensics investigator needs to understand both the legal side and the technology side. Cloud computing is another large item because on-demand access to remote software, remote servers, is becoming an issue. NIST, the National Institute of Standard and Technology, defines the cloud in terms of three major services: software as a service, platform as a service, and infrastructure as a service. 4 deployment methods do exist: private, public, hybrid, and there's a community one. Though this really isn't a cloud computing type course, this is more of an FYI just so that you're aware. But we need to have a basic understanding of these cloud models just in case. Alright, let's get a little bit more in tune with that. Software as a service refers to applications provided to a customer. Software as a service. So you don't have to care about the underlying operating system. Platform as a service is more of a business model where you can spin up selected platforms so you can install your own application and software. Infrastructure as a service is more like the bare metal machines, the environment. That way you can install your own operating systems, your own applications, your own tools, and you don't have to worry about purchasing the underlying technology. One of the common ones is understanding these deployment types. The most secured is typically a private cloud, and that's where the client owns the hardware and has physical access to that cloud. Community cloud is for people or organizations with similar interests or similar businesses that may share resources. A public cloud is where a person's files are on the same physical machine as another's. For example, public clouds could be like OneDrive or Google Docs. And then a hybrid could be a combination of both. That's where you could actually run your own physical hardware, but you also then share access to that equipment or to that cloud with other individuals. In civil cases, evidence is acquired by issuing a request for production. One company requests physical electronic documents, and the second company produces them, while a criminal case requires strict adherence to the chain of custody. Criminal normally involves the government or the state to ensure evidence hasn't been tampered with or altered in the process. This normally requires some type of subpoena or search warrant or thereof. In digital forensics, typically if we're dealing with computer forensics specifically, we're capturing an image of a hard drive. If we're dealing with other types of forensics, we may be capturing some type of long-term storage or a capture of that device. That way we can be retrieving data off of that copy. We do not work off the original, we always work off of a copy. That copy is a specialized copy. It's typically called a bit stream copy when we make a bit by bit copy of the original. Again, we work off of the copy. That way, if anyone needs to do their own forensics investigation, they can make another copy of the original and run their analysis. Because hard drives are increasing in size, acquisitions are common. There are two major types, like a live acquisition, and that's done while the machine is running. That allows us to also look at memory, and we have just a static acquisition, memory forensics. The question before the court is that the result of a live acquisition might not be reproducible, so that does violate a forensic standard. Hence why we have to find ways of verification of our copying. There are techniques out there that will allow us to some degree a understanding of what we're copying and verifying what we are copying. Looking at the tools, there are two large companies, Access Data and Guidance. Guidance makes InCase. They both have e-discovery tools that work independently or with their digital forensics toolkits. If a company has its own digital forensics team and legal team, typically their efforts can be correlated more easily with these tools. Major e-discovery tools are discussed more in Chapter 3. But again, Access Data and InCase are two of the large companies. Large multinational corporations may be able to afford these expensive toolkits, while smaller and medium businesses aren't. So there are some freeware, shareware, Linux versions, but one of the problems is you have to have skills to be able to use them. E-discovery and forensics is very time consuming. Going through all the data to sort for information is a very daunting task. So, cost and time can be reduced by asking what information is needed to prove a case. What information do you have to have in order to do this? If you're dealing with federal cases, we have three major items: Federal Rules of Civil Procedure, Federal Rules for Criminal Procedures, and Federal Rules of Evidence. Each state has its own interpretation of these, but these are federal. So if you're dealing with a federal case, these are the areas you're going to be dealing with. So let's go and look at the civil procedures, FRCP. Those involved with e-discovery are Rules 16, 26, 33, 34, and 37. Again, we're not going to go into the rules in depth. Typically, that's why you have a legal team or a lawyer that will help the process or the review of this. Rules for criminal procedures established in 44. The Supreme Court specified that when dealing with someone's charged in a criminal case, the right of the individual takes precedence, meaning the main rule that addresses digital evidence in this is Rule 41, search and seizure. While in 2002, the Department of Justice redefined searching and seizing computers and obtaining electronic evidence in a criminal investigation as a new document. Federal Rules of Evidence, drafted by the U.S. Supreme Court, became law in 1975. These apply to evidence presented in court for both civil and criminal cases. It's part of the introduction to digital evidence, and it hasn't changed the FRE extensively. Does this add many new interpretations to old rules? Yeah. Hearsay rule, for example. The text message and email might prove the recipient had been told something. However, messages can't prove the information accuracy. Hence the hearsay rule. Further rules of evidence could be things such as FRE, rule that have an impact on how e-discovery is performed, Article 1, Rule 103, 105, and 106, Articles 4, 7, 8, and 10. Again, we're not dealing with what the rules are. That's where we'd be contacting a legal expert. The important aspect of ESI is its overwhelming volume. There's so much data to be able to go through. Digital information may be stored in physical locations or moved intermittently. So locations, as a result, could be all over the place. Locations of data can affect which country's laws are in effect for that e-discovery. Emails, if they are in another country, are subject to that country's law. So do keep that in mind. What's interesting is we have certain like Sedona Principles that will create special groups of professionals and lawyers that help write guidelines for handling e-documents. They emerged from a conference in 2007. They are helping to design to ease the burden of e-discovery, and they list 14 principles that link to the FRCP, and they've laid the framework for what companies must do to prepare for possible litigation. There is a structure for this. In April 2006, the U.S. Supreme Court ordered that FRCP be amended to address e-discovery. Basically, they required companies to protect data that might be subject to discovery in anticipation of litigation. The Advisory Committee on Civil Rules incorporated the Sedona Principle in 2006. The amendment is Rule 26B2, and this permits parties to avoid discovery of ESI that isn't reasonable accessible because of the undue burden or the cost. This will include electronic information that has to be converted to recoverable to be usable. Again, undue burden or costs. We have to have a working definition of them to see how they actually translate to real world. Other amendments are 34B, and that dictates that ESI be provided in a form that is readily usable. If the requested party specifies another form, the producing party has the option of objecting to the form and proposing its own form. Organizations that scan paper documents and replace them with electronic copies, such as PDFs or TIFFs, though PDF is the more common format. This improves information management capabilities and are better positioned to handle litigation. That they're already in common used formats makes it better. Besides scanned documents, we have things like the optical character recognition, or OCR. OCR software examines scanned pictures of documents and recognizes letters and numbers, so you can actually have a form fillable or a editable document based off of that data. Nice thing is, native files will be able to be searchable or indexed, so that's always a huge plus. When we look at other FRCP Amendments, lawyers have a duty to preserve evidence that is relevant to the actual or potential litigation. So it has appended FRCP Rule 37F, which states the court cannot impose sanctions when a party destroys ESI as part of its routine and good faith operations. Spoliation is a party wrongfully destroying evidence, but again, if it's part of the routine that's documented and is able to be proven, then that's different. Companies should put their ESI retention policies in writing, and thus being able to prove that the policies do exist, and you're able to show that you followed them routinely. Procedures should also be drafted to place a litigation hold on potential relevant ESI. You'll notice in exchange there is actually a litigation hold or hold function for email retention policies, for the policies and for mailboxes as a whole. FRCP clarifies how ESI is handled during discovery and how it should be destroyed when it's no longer legally or operational required. ESI retention might be affected by IRS rules, corporate policies, or other ongoing projects, so do keep that in mind. Policies and procedures should be reviewed and updated as needed with General Counsel. State amendments related to ESI, they do exist. Many states have adopted provisions to address procedural issues with e-discovery. Texas, for example, has developed rules for ESI discovery even before the FRCP amendments were passed. States' rules can be more stringent than federal rules, but not more lenient. The most strict rules should apply. States cannot be more lenient than the feds. 30 states have adopted some type of e-discovery procedural rule, and this is reflected in the 2006 FRCP amendments. 8 other states have some form of e-discovery legislation pending. So shortly we should have all of the states with their own e-discovery legislation. United Nations also have theirs, developed as a result of the burgeoning e-commerce in the late 90s. Multinational corporations had an issue. Cases can span several continents and jurisdictions, hence the growing concern and growing issues. So UN model law focuses on civil procedures, and they have been used as a basis for both digital forensics and e-discovery worldwide. We also have European corporate laws. Again, most European companies that conduct business in the U.S. feel compelled to improve internal controls in response to U.S. demands, because the U.S. in this regard has more stringent controls. The EU 8th Company Law Directive, sometimes described as the Europeans' SOX, slightly different from the US-based SOX Act, that basically provide foreign corporations that want to be listed on the US Stock Exchange will have to comply with the SOX provision. Other directives like the 4th, 7th, and 8th, and they have their own specific directives like 78, 660, 83, 349, 84, 253, and so forth. Again, when you start dealing with this type of nitty-gritty law, you're looking at consulting a lawyer who specializes in this area. In accordance with the amendments, EU countries are enacting new laws, informally known as the Eurosox, to help deal with this. Email communication is a crucial component with business, so email records should also be maintained in a format that facilitates searching so that third parties may review if necessary and or have the appropriate credentials or paperwork from a judicial oversight area. This Canadian Rules for Civil Procedure, again, 2006, subcommittee of the Canadian Discovery Task Force created to deal with e-discovery for Canadian courts were created. 2010, Ontario amended its rules for civil procedure to address ESI discovery as well. One of the biggest challenges is legal professionals' lack of knowledge in dealing with e-discovery. Again, that's that legal/IT. Part of the 2010 Ontario rule was parties in a lawsuit agree on and file a written discovery plan within 60 days after close of pleading. The discovery plan shall be written and include intended scope of document discovery, dates, services, affidavits of documents, information respecting the time, cost, and manner of producing documents, and other information intended to complete the discovery process. Important principles related to ESI for the Canadian rule, principles 1, 3, 4, and 5, and again, this is more in-depth than what we need to know, but understand there is a structure in place. Principles 8 and 9 as well. There is the Sedona Canadian principle, and the Ontario checklist for preparing for discovery plans are part of that procedural law as well. Here, that is Rule 29105 of the Ontario Rules of Civil Procedure, and it states that the courts can refuse to award any cost if parties haven't agreed to a discovery plan. Also, the court can impose cost penalties and other sanctions if necessary. And that is Chapter 1 in a nutshell. We talked about what e-discovery is, the tools, federal law, evidence, criminal procedures in the U.S. We talked about UN, Europe, and other countries' laws as well. If you have any questions, please let me know. Thank you.